to cover in this program, and if we don't get started at 9, we're never going to finish. To make things a little bit snappier today, we're not going to go through lengthy introductions of the various speakers. Most of the CVs are contained in your materials. I'd like to thank the members of the Planning Committee who worked very, very hard at putting this program together, 2 of whom are seated here. To my right is Paul Bates. To my left is Derry Millar, and I'd like to thank as well Master Sandler and Sheila Block, who are not here as yet. We're going to start now with the section on pleadings, and our first 3 speakers are Derry Millar, Tom Heintzman. His CV isn't in the file, so I'll just give you a brief update on him. He's a partner at McCarthy's in the civil litigation section. He has lectured at Osgoode Hall Law School in the University of Toronto, and he has been an instructor in civil procedure and the administrative law sections of the bar admission course. And our third speaker in this segment will be Paul Bates. Would you please welcome them? Thank you.
Thank you very much. We have a very long program that I think you will find very interesting and informative. The topic that I've been assigned is pleadings. The best defense is a good offense, creative counterclaims, cross-claims, and third-party claims. Basically, it'll revolve around the tort of the civil abusive process. And one of the things, the principal things that I would like to message that I would like to get across is that when you have any problem, analyze it and see from a defendant's perspective what claims there might be that you could properly assert against the plaintiff or its allies or against others. The broadest scope for creativity and the use of your imagination is with respect to counterclaims. As you know, you may assert any claim against the plaintiff by way of counterclaim that you have against the plaintiff or the plaintiff and its allies. It's not the same. You don't have the same scope with respect to cross-claims or third-party claims, but there's lots of things that you can do. There are a number of ethical considerations that you have to bear in mind when considering potential cross-claims or counterclaims. You must remember that you can't simply weave a claim out of nothing. The claim must be reasonably based. As I noted in the paper, adding parties simply as a method of obtaining information is not, in my view, necessary or proper given the broadening scope of discovery and the provisions of Rule 3011. When considering adding claims, be they a counterclaim, a third-party claim, or a cross-claim, got to think about some of the tactical advantages and disadvantages. The one principal disadvantage is that you may bring into your litigation someone like Tom, who's a very formidable foe, or a client who thinks his terms of civil litigation is out and out war and won't resolve it unless there's absolute and total capitulation. An advantage may be, in the appropriate case, you may split the plaintiff and his or her ally. The theme for this paper came about really as a result of a discussion at the planning session, and the question that was posed by one of the members of the planning group, and that question was whether or not it's permissible to counterclaim in the plaintiff's action for the tort of abusive process. The abuse of the process being alleged to be the commencement of the plaintiff's action. I tried to set out in the paper at page 7 the statement that is most quoted in terms of what is the abusive process. If I might briefly, or what is the tort of the abusive process, refer to that statement. The gist of this tort lies not in the wrongful procurement of legal process, of the wrongful launching of criminal proceedings, but in the misuse of the process, no matter how properly obtained, for any purpose other than which it was designed to serve. The essential elements of the tort of abusive process are Firstly, as stated in Fleming, a collateral and improper purpose, such as extortion. Secondly, a definite act or threat in furtherance of a purpose not legitimate in the use of the process. Some overt act is essential because there's clearly no liability when the defendant merely employs regular legal process to its proper conclusion, although with bad intention. Prior to the decision of the Associate Chief Justice of the High Court on April 7th of the last month in a case Vito Industries and Expire Properties, the answer to the question posed whether or not you could counterclaim within the plaintiff's action for the tort of abusive process, my answer would have been no. Starting back in 1975 and 1977, this issue was canvassed by judges in a case of Greenwood and McGee in 1977. Mr. Justice Southey struck out a counterclaim based on an abusive process as disclosing no reasonable cause of action. In that case, he said, among other things, if such an action does lie, however, I am satisfied that it is premature to bring such an action by way of counterclaim in the civil proceedings which are alleged to be a malicious abusive process of the courts. Because the cause of action is not complete until those proceedings have been dismissed. I don't necessarily agree with that, but that's what he said back in 77. In 1975, Mr. Justice Parker, as he then was in the case of Atlan Containers, also struck out a counterclaim for abusive process. And what he had to say was very instructive. I've set out this passage at page 9, but he says, in the case at bar, the defendant claims for damages because the institution and prosecution of the plaintiff's action has caused and will continue to cause serious financial loss to the defendant. It follows to its logical conclusion, every plaintiff would be open to such a claim. However, the law regarding the abusive process is very narrow in scope. It is only where the process of the court is used for an improper purpose and where there is a definite act or threat in furtherance of such a purpose. No such act or threat is pleaded in this case. In any event, the counterclaim is not a proper subject matter for inclusion in this type of action, since the causes of action are not similar in type. Mr. Justice Parker did two things. He said the tort of abusive process is not the proper subject matter of the counterclaim. And secondly, in this case, he said there was no overt act pleaded. In 1986, Mr. Justice Henry, in a case Stosopoulos and Commercial Union Assurance, again considered a counterclaim for tort of an abusive civil process. In that case, the plaintiff was suing the insurer for a declaration of entitlement to no-fault benefits and punitive damages. The counterclaim by the insurer for abusive process was made on the basis that the plaintiff's claim for punitive damages was made for the improper purpose of pressuring the defendant to settle. With respect to this purpose of pressuring the defendant to settle, Mr. Justice Henry said, in my opinion, it may therefore be said that any action may be viewed as having as one purpose the promoting of a settlement of the underlying disputes without final resort to trial. The policy of the rules of civil procedure is to encourage settlement. The motive for the claim for punitive damages is not material, as it is a proper claim to be made in a properly lodged action, whether or not the plaintiff ultimately succeeds or has a doubtful case before. In that case, there was no overt act pleaded beyond the statement of, beyond the fact that an action had been started, and he therefore struck out the counterclaim. In January of this year, Master Sandler had occasion to deal with this issue in the case of 623854 Ontario Limited and Sussy Holdings. In that case, he struck out the a counterclaim for abuse of process based on the claim having been made on the grounds that A, it was premature, and B, it was not the proper subject matter of a counterclaim. Last month, Master Clark and Bentham and Rothbard refused to amend the statement of defense to add a counterclaim for abuse of process on the basis that on the material before him, the material did not disclose a reasonable cause of action. In that case, there was no extrinsic act or threat pleaded. In two cases, the counterclaim for abuse of process has been allowed to stand. The first of those cases is Maegan Commercial Union, which is dealt with in Mr. Justice Henry's judgment in Tosopolis and Commercial Union. I couldn't find a report of that case anywhere, and I didn't get a chance, frankly, to go back to the file, presumably because Commercial Union was involved in both of them. The counsel for Commercial Union brought to the attention of Mr. Justice Henry the decision of Mr. Justice Katzmann and Maegan. In Mr. Justice Katzmann's case, he permitted the defendants to amend. He refused to strike out the counterclaim for abuse of process. He permitted the defendants to amend, or granted them leave to amend the counterclaim to plead, presumably, the overt act outside of the plaintiff's action. In Lido Industrial, which was heard last month, and which, until I started to write this paper, as I said, I thought the answer was going to be no, you couldn't have your counterclaim for abuse of process. This Lido case was heard by Mr. Justice Callahan last month, and the pleading is interesting, and I've set it out on page 11 of the paper. The only part of the counterclaim that relates to the tort of abuse of process is this. The defendants state, and the fact is that the filing of the statement of claim by the plaintiffs is only for the reason of attempting to cause financial embarrassment and economic harm to the defendants, and thus is frivolous and vexatious and constitutes an abuse of process. The defendants therefore state that the plaintiffs are liable in damages for any economic harm the plaintiffs may have caused, and are also liable in damages for intent to cause such harm, full particulars of which will be provided at trial. This counterclaim was asserted in an action that relates to leases and a lease dispute with respect to commercial tenancies. The pleading sets out no other facts in support of the claim for damages for abuse of civil process. Notwithstanding that, the pleading is nothing beyond the fact that the action has been started. Mr. Justice Callahan said that pleading, however imperfect, advances a claim for abuse of civil process. It cannot be said that a claim for abuse of civil process as alleged herein discloses no such a cause of action. The Lido case appears to be a departure from the earlier cases which required the pleading of an extrinsic act beyond the plaintiff's commencement of its action in order to found the tort of abuse of process. It should be noted that in the Lido case, it got to Mr. Justice Callahan not really as directly on point as to considering the tort of abuse of process. There was an appeal from the master's decision striking out the whole counterclaim, and part of the appeal dealt with whether or not there was jurisdiction in the master to do what he did. But the comments that I've related with respect to the tort of abuse of process were made in that case in that context. It's interesting, at least in our office, I finished this paper on a Monday, and on a Friday we had a partner of mine had received in an action that's a fairly heavy fought action where there's a large number of very large claims, a claim that is basically the abuse of civil process. And he had thought that in the ongoing litigation that his opponent could not bring this action for abuse of civil process. I gave him my paper so that he could rethink his position, or at least take a look at it again. It seems that this tort is going to flourish and grow, and I commend to you the cases that have been cited on the paper. Thank you very much. The next speaker will be Tom Heintzman.
Good morning. My paper is on the new rules of civil procedures. Do they have an impact on service out of the jurisdiction? And the message that I want to leave with you is yes, in a total overall approach to service out of the jurisdiction, the new rules do make a difference, but they don't make the difference that the authors and drafters of the rule thought they did. See if I can get this thing to stick on me. And what I think is going on here is a confluence of a number of factors that the court has to recognize and has so far not recognized in Ontario. First of all, there is the amendment to Rule 17 from the old Rule 25, the Rule 17.02. The second factor is the elimination of a conditional appearance. The third factor is the new approach by the court to forum convenience. And the fourth factor is the new Rule 17.03. And what I'm suggesting to you is that when you take those four factors together, we now should have a new approach to looking at service ex juris, which hasn't really been enunciated by the court. And what the court should do, you'll see in my conclusion of the paper, should recognize that it now has to determine this issue at the beginning of the action and make a substantive decision rather than delaying the issue until trial. So that will bring new considerations to bear. And that B, its function really now is to take what is said in Rule 17.02, which is a statement by the Rules Committee of the usual basis upon which a process should be served out of Ontario, and adjust that back and forth, round out the edges, and adjust the facts to those principles to extend Rule 17.02 outwards where the particular case requires and inwards where the particular case requires. Prior to 1975, the rules required an order before you could serve a statement of claim, a writ outside of Ontario. And I have set forth on pages 2 and 3 of my paper the 5 factors that the court looked at in order to determine whether service should be allowed out of the jurisdiction. The fact that a foreign state sovereignty was being infringed, the merits of the plaintiff's action, whether there was full and fair disclosure, any doubt about the application of the rule to be given to the foreigner, and fifthly, the issue of foreign convenience. Now, all of those factors were considered by the court both at the time that the order was sought to allow process to be served out of the jurisdiction and when it was attacked thereafter. When the rules were rewritten in 1975 to eliminate the necessity for an order before process was served out of the jurisdiction, debate raged as to whether the discretion in the court had been eliminated. And that was finally settled in the Court of Appeal in the Singh and Hayden Petroleum case, in which Mr. Justice Arnott said that the discretion had not been eliminated. All that had been eliminated was the necessity to obtain the order, and therefore the court should look at the matter as if it were considering an application under the old procedures at the time the application was made to set aside service. Now, the commentators, and indeed the Rules Committee, in their presentation of the new rules, suggest that that discretion has now been eliminated. And to my way of thinking, that's not correct and should not be correct. First of all, looking at the rule itself, the new Rule 17.02 is no different in substance than the old Rule 25. So the commentators look to Rule 17.06, which is the rule that permits you to apply to set aside service, and say that because of the way Rule 17.06 now reads, that the discretion has been eliminated. And they say that because the rule says that you can move to set aside service if service outside Ontario is not authorized by these rules, or that Ontario was not a convenient forum. Now, to me, that's not a sufficient reason to say that the discretion has been eliminated merely because the rule says that service can be set aside if not authorized by the rules. To me, that doesn't eliminate the necessary discretion that's involved in determining whether process should be allowed to be served out of Ontario. Because, of course, even under the old regime, that's exactly what the plaintiff and the defendant were arguing about. Rule 29 allowed an application to be made to set aside service, and you would argue that the service was not authorized by the rules, but you would also argue that in the court's discretion it ought to be set aside. And I don't think that the way the rule is now framed should eliminate the court's discretion for a number of reasons. There is so much indiscretion in such an application. First of all, we now have, in a re-enunciated state, the forum convenience consideration. It's now right in the rule that the court should look at forum convenience. The interpretation of the rule requires an exercise of the court's policy-making function, its discretion-making function. If it has to interpret the rule, it has to apply a discretion, and let's call a spade a spade. Thirdly, the facts of the case have to be analyzed to determine whether they fall within the rule. And as I develop on page 6, and this is the most serious problem that we're now facing, is that if the court thinks that it has no discretion, it won't accord to the foreign defendant the proper consideration that he's entitled to as to whether the rule applies. The court will look at the rule and say, well, it's a contract alleged to be made in Ontario. It's an arguable proposition. Mr. Foreign Defendant, we're not going to go any further. And the point that I'm making in the paper is the court having eliminated conditional appearances, the court must now look at the facts and say, was that contract made in Ontario? I'm not going to decide whether there was a contract. That's the issue in the action. But what has to be decided, taking Rule 17.02 FI, was it made in Ontario? The older decisions say, well, we can defer that to trial. But the reason they say that is because we used to have a conditional appearance. Now that we don't have that conditional appearance, the decision has to be made at the commencement of the action. If it has to be made then the court has to exercise a discretion and look at the matter in substance. Another factor that I point to at the bottom of page 6 and the top of page 7 that relates to discretion is the whole question of nondisclosure. Now, nondisclosure in the old days used to be in the form of your affidavit. If you didn't have something in your affidavit that some court later in 2020 hindsight said should have been in your affidavit in your application for leave to serve out of the jurisdiction, your service was set aside. And that happened to me on a couple of occasions, and everybody says, well, why didn't you put fact X into your affidavit? Well, I didn't think it was relevant. So in the old days, you could have your process struck out because you did not make full and fair disclosure. The rule presently requires, Rule 17.041, that the statement of claim or originating process shall disclose the facts and specifically refer to the provisions of Rule 17.02. The issue is if you materially distort in your statement of claim or in your notice of application and your supporting affidavit, if it's that kind of an application, can your process be set aside because of non-disclosure? That's an issue that hasn't yet been discussed, but it's a possibility. The fourth factor that I refer to on page 7 that used to be considered is the merit or the merits of the plaintiff's case. And I think it can be strongly argued, and is probably the law, that that issue is no longer going to be looked at the time that service out of the jurisdiction is scrutinized. So that's the re-amendment or the amendment of Rule 17.02. In my view, it shouldn't eliminate. The issue is, does it eliminate the discretion that the court has, or do you just apply the rule, and if you fit within a sub-rule, that's the end of the issue? I don't think that should be the law, but there's no determination either way on that point. The next issue that I deal with is Rule 17.03, and Rule 17.03 now allows an order permitting service out of the jurisdiction even if you don't come within Rule 17.02. And a companion rule, 17.063, allows you to, in effect, rely upon Rule 17.03 if your process out of the jurisdiction is attacked thereafter. So you can get an order, as it were, nunc-pro-tunc after service to say, even if I don't fall within 17.02, validate my service, because this is a case that ought to be tried in Ontario. I then refer to Rule 17.04, again on page 8, just to draw your attention to the Bachman case, which held that the requirement in Rule 17.04 that you disclose the facts and refer to the rule will be applied against you if you're the plaintiff serving out of the jurisdiction, and you will not be able to sort of hope or pick through the statement of claim and say, well, if you put all of that together, really I have there a contract made in Ontario. The master's not going to let you do that unless it's very clear. So at the end of your statement of claim, you should take a specific paragraph and say that the facts relied upon for service out of the jurisdiction are, and state them specifically and separately, and then refer to the rule. If you just say, I rely on Rule 17.02 FI, that's not going to be good enough. Now, in that case, the master refused to issue an order validating service, but my experience has been that most judges are willing to do so, and indeed, if you smell your opponent making a Bachman type of argument, you should immediately go and amend your statement of claim, as you now have a right to do before pleadings are noted closed. I then deal with the whole question of when you return to the jurisdiction. And you have to watch very carefully that you don't do something that returns you to or submits you to the jurisdiction if you're acting for a foreign defendant. I almost had a heart attack in one case in which I was involved in Newfoundland, where the plaintiff took the position that the motion, in the way it was brought, had amounted to an interment of the jurisdiction, because at the same time as making a motion to set aside service, I was also in effect saying that there were parts of the statement of claim which were improper. Don't do that, because by taking a shot at the statement of claim, you can, in effect, turn to the jurisdiction. It is now clear that merely bringing a motion to set aside service does not amount to turning to the jurisdiction, but delivering a notice of intent to defend probably does amount to a submission to the jurisdiction. So don't deliver a notice of intent to defend if you intend to strike out or seek to strike out service. I point out on page 10 and 11 that conditional appearances have now been eliminated, and I want to make the point and stress the point that I make in the last sentence on page 10, where I say, by virtue of the rule permitting a conditional appearance, a court was often willing to allow the plaintiff to serve a statement of claim that arguably came within the rules without making a definitive decision at the time that the service was attacked. And if you read those cases at tab J, they're exactly that. They're cases where the Court of Appeal said, well, the plaintiff, he's sort of come within the rule, so we're going to allow service out of the jurisdiction. But if you read the last sentence in those cases, the court says, but there's still an issue, so we'll let the defendant enter a conditional appearance. So if you're faced with this argument well, Mr. Heintzman, the plaintiff's got something that comes pretty close to 17.0 to FI. Shouldn't we let him go ahead? The answer is no. Those old cases that said that were in a regime of conditional appearances. Now he has to bring himself within the rule. He doesn't have to show that there's a contract. That can be argued later. But he has to show that there was a contract made in Ontario, if there was a contract. And that issue now has to be determined on its merits at the time of the application to set aside service. How am I doing on time? Am I over? Okay. Forum convenience. This issue has exploded in the last 20 years, and I have given you most of the English cases which have caused the explosion. In effect, the House of Lords, starting in 1974, said to the English judges, we've been acting very parochially all these years, thinking that we are a superior race of people and that everybody should have the opportunity to litigate in the English courts. That's no longer going to be the rule. The Turkish courts are just as good as the English courts, and if the case should properly be determined in Turkey, we're not going to determine it in England. Under the old rule, you had to prove that the bringing of the action in England was oppressive and vexatious. A very, very stringent test. You could bring almost anything in England. Showing that it was oppressive and vexation was just about impossible. Ontario, thinking it no less a place than England, adopted the same rule. And so until the 1970s, we applied the same test. Now, all of that is gone, in my view, through the Bonaventure Systems case, referred to on page 13, which adopted the McShannon test, the test enunciated by the House of Lords in McShannon and Rockware Glass. And the test is now a twofold test, which I've quoted from Mr. Justice Ewischuk's judgment on page 14. And there's no doubt in my mind that forum convenience is the most important principle that you now apply when you attack or uphold service out of the jurisdiction. If you can demonstrate that you're in a convenient forum, that Ontario is the convenient forum, really everything else is music. And there's two things that you look at for forum convenience. First, and the applicant, the foreign defendant, has the burden. He has to prove that there's another more convenient forum. And the way he does that is, first of all, identifying which is the natural forum. If he can establish that California or Quebec is the natural forum, when you look at the facts, they naturally fit into Quebec or Nova Scotia or California, then he gets a presumption on that issue. But he's got the burden of proof. If he can show there's another natural forum, he's going to get a long way there. The second issue is the resident plaintiff can still hold his service even if there's another more convenient forum, if he can show that there is a personal or juridical advantage in proceeding in Ontario. And I've given you at the bottom of page 14 a number of examples where courts have said this plaintiff has a personal or juridical advantage in proceeding in Ontario, and therefore, notwithstanding that New York is the more convenient forum, we're going to let this action go ahead in Ontario. On page 16, I point out another ground that you can rely upon, which isn't found in Rule 17, and that is the existence of another action, or lis alibi pendens. And you should be aware of that principle, and if there is another action between the parties, you should move to set aside the action in Ontario on the basis that there's another proceeding in California, my lord. The proceeding in this action should go forward in that action. Unfortunately, the way the rules are structured, the application must be brought before a judge if you're relying on lis alibi pendens, and you can get all messed up with appeal rights and remedies if you have some parties, as happened in a recent case in which I was involved, who were not entitled to rely upon lis alibi pendens and some parties who were. I've given you some examples of some recent principles dealing with Rule 17.02, and I won't review those in detail. The most important new rule, or relatively new rule, is 17.02H, damages sustained in Ontario. And while the courts originally were saying, well, almost any plaintiff in Ontario suffers damage here, the door is wide open. The door is closing now, and the courts are saying it can't be that the Rules Committee thought that by Rule 17.02H, anybody who sustains damage in Ontario can sue here, because everybody who's here presumably is continuing to suffer damage. So the rule is being narrowed, and together with the principles of forum convenience, you've got to show some good reason why the action should be tried in Ontario, and not merely that the plaintiff is suffering damage here. I also refer you to Rule 17.02Q, which allows counterclaims, cross-claims, and third-party claims to be brought in Ontario if the main action should be tried here. And that's a very valuable addition to the rules, and it will enable you to bring in a foreign insurer or other third parties who should be brought into an action, not because the third-party claim is conveniently tried in Ontario, but because the claim itself should be tried here, and there's no sense in trying the third-party claim anywhere else. So let me finish up by the words that I say in the conclusion. When you're faced with one of these applications, look at the old rules, look at the old principles, and decide in your own mind, because the court hasn't, how they should apply to your case. Don't let the judge off the hook by saying that the plaintiff has an arguable basis for coming within the rule. That's not a sufficient ground. The judge has to make a decision now, at that point, as to whether this proceeding should proceed in Ontario or not. And what he has to do is, with the discretion he now has in Rule 17.03 to go outside the rule, 17.02, or inside the rule under his old discretion to determine whether this proceeding should be tried in Ontario. And he's going to apply forum convenience very much to making that determination. Thank you.
Well, my assignment is limitation periods, and I've been asked to deal with the question whether there are limitation periods anymore. Now, let me say at first that I find that to be a remarkable question when you consider that limitation periods are derived from legislation, entirely from legislation, and there has been no new legislation. Nothing's new on the legislative front, but we still have a shared perception that there's a lot happening in limitation periods and that they seem to be eroding or going away. There are three reasons for that, I think, three predominant reasons. The first is the discoverability principle. That says that time begins to run when the plaintiff knew or ought to have known the material facts on which the action is based. And that is the meaning to be applied to any limitation statute, as with most, that say that time begins to run when the cause of action arose. So that's one new area. A second new area is that of minors' claims or minors' actions that are governed by Section 47 of the Limitations Act. That section has been said by the Court of Appeal to mean that, as it says, time does not begin to run against a minor until they reach the age of an adult, 18 years in Ontario, and that principle applies to most causes of action and most defendants. And the third new area, which I'm going to mention, is what I call discretionary relief from limitations, and it has two branches. There are statutes which contain a power to give discretionary relief from an expired limitation. The Family Law Act, Section 2, 5, and other statutes that are covered in the paper do this. What is happening is that the courts are delighted to exercise that power, and it is very easy to get discretionary relief. The tests vary from statute to statute depending upon the criteria that are set out, and there's no uniformity in the various statutes about the criteria for getting discretionary relief. But it's an easy thing to get. The second branch of discretionary relief arises from a recent unreported decision of Mr. Justice Montgomery, who says that there is an overall overriding discretion in the court to give relief from a limitation period where it would be just to do so. It doesn't have to be founded in any statutory basis nor in any basis in any rule. There isn't any basis in the rule. It's just an overall discretion in the court where it's just to do so to give relief from a limitation period. Those are the new developments, and that's why the question is, are there limitation periods anymore? The answer that I would give you to the question is that yes, that there are limitation periods, and that it's the legislature's intention that all claims, whether they're strong or weak, be barred after the expiry of time at some point. After the expiry of a reasonable time was one way to express it, but certainly there is an intention that all claims be barred after a reasonable time. And that intention was there when the limitations legislation was enacted, and it's still there today. But what's missing is judicial recognition of that. Now, if you accept that that's the policy, and Ontario doesn't stand alone in having that policy, every jurisdiction does. American jurisdictions do, and all provinces do. But if you accept that that should be the policy, then I think there are three questions that have to be asked in order to understand a limitations problem, and it's those questions that I would like to discuss. And they are, to me, a recipe for how to resolve a limitations situation. And the first question is determining when time starts. Let me say as I go through these that there is no inherent complexity in resolving a limitations problem. You have to determine when time starts, how long time runs, and what happens when it's expired. And if you know the answers to those questions, which shouldn't be difficult to determine in principle, then you will know the answer to the limitations problem confronting you. What I'm going to discuss in briefly canvassing each of the three questions is that they're not simple and there's quite a problem. The first question, when does time start, is the most formidable. You first of all have to go through a limitations labyrinth of legislation to find the right section. You have to sort the facts according to at least three criteria, namely the type of cause of action, the identity of the parties, and the third one to me is a general category of anything else that matters according to the particular statute that it comes under. If it's an engineer's problem or a medical professional problem or an accountant's problem or a crown problem, I could go on and on. You only have to look in one place, I'll tell you momentarily, to appreciate the number of things that fall into the residual third category that you have to invent on a case-by-case basis. So I say there's a limitations labyrinth, but I also say there needn't be, because in 1981, I think it was, Attorney General McMurtry put forward a bill, which was then number 1983, in which all limitations were wrapped into one act. And it was provided that if a limitation wasn't found in the act or in the schedule of special acts that are found, that's referred to in the act, then it's of no force or effect. So that takes away some of the labyrinthian effect of limitations. You only have to go look in one place, and I make the point in the paper that consumers of legal services shouldn't be paying for each of us every time a problem comes up to have to search to try to find the applicable law. So that's the first point, is finding the right statute. There are some limitation periods that you can look in vain for because limitation statutes are not comprehensive. There are equitable claims for things like unjust enrichment, rectification, promissory estoppel, and others that are not covered, apparently not covered, by limitations statutes, because the statutes are derived from common law legislation enacted in England to deal with common law actions. Those are equitable claims. The second grouping that isn't covered by limitation statutes is claims by the provincial crown. And finally, there's a small category of federal causes of action, which I know a lot about personally, but I believe patent actions is an example, that aren't covered by limitations. Now, the second thing you have to do to determine when time starts, and we're still on deciding whether time started, we haven't dealt with the other things, is you have to determine what the statute, when you find it, says. If it says that time starts when the cause of action arose, then we've already seen that the discoverability rule applies. But it may also refer to the commencement of time at the happening of a fixed and definite event, like the time of last treatment in the case of some of the limitation statutes that apply to medical professionals. The former is more uncertain, the latter is much more certain. The next step in deciding when time starts is to consider persons who aren't subject to the limitation statute. That's the Crown, I've mentioned. Persons under a disability, essentially minors in mental incompetence. Persons out of the jurisdiction. And there is also the possibility that new causes of action may not be covered by any limitation statute because it wasn't there to be provided for when the legislation was brought in. If a cause of action is recognized for invasion of privacy, I think you could look in vain to find a limitation period for it because it wasn't recognized when the limitations was brought in, and there is no residuary ultimate limitation period that says that where nothing else applies, everything is barred after a certain time. The final thing that I'm going to mention that deals with when time starts is equitable, what I call equitable considerations. Estoppel, waiver, acquiescence, fraud, the general discretion that Mr. Justice Montgomery has referred to in a recent decision. All of these things may prevent the commencement of time. But if you've got through all of that, you will be able to have determined whether time has started. That's the most formidable question. How long does time run is not too difficult. It's right in the section of the applicable legislation. Could be 3 months, 6 months, 1 year, 2 years, 4 years, 6 years, 10 years, 20 years. There's at least those many classifications. I didn't read every statute to try to see if there are others. But the final question is, what happens when time has lapsed? Now, you might think it means that the action has to be dismissed. And it might, but it might not. If the beneficiary of the limitation period, the defendant who says he has a limitation period, is sought to be joined in an action or to be subjected as an existing defendant to new claims in an existing action, then the limitation period may not be of any effect. It might be extended by legislation, like in the Negligence Act, Section 9, or it might be extended by what the Supreme Court of Canada called the special circumstances test. So that although the limitation's there, and it's lapsed, and it's expired, there are cases where you can bring someone into an action, or in an existing action, you can add a new claim well out of time, provided you comply with get around certain hurdles. Another reason why an expired limitation period may not be of any defense is that it might be, the court would exercise a general discretion, would say that there's no real prejudice, although the limitation period is long expired, the records are still available, the witnesses are still alive, and therefore the claim can be brought. I've said in the paper that I don't agree with that general discretion, but there's a case which says it's there. Now, if all else fails, you can get around limitations in one other way, and that is that they are procedural. Ontario courts apply Ontario limitations. Ontario courts don't apply the limitations of other provinces, and the same is the case for other provinces looking upon Ontario's limitations. So that, we've just heard a good paper on dealing with jurisdictional problems. You can put these two together. You can go around a limitation period in one province by going to another province, provided you can otherwise get the case heard in that other province. And what I've dealt with, let me say that the questions that I've tried to deal with are, when does time start, how long does it run, and what happens when it ends? And I've referred just in passing to a whole series of variables and ifs and questions that have to be resolved. What I invite you to take from that is that limitations is unduly complicated, and that there is a fair perception that things are changing, but there is missing a sufficient respect by the judiciary for the intention of the legislature that all claims, good ones and bad ones, be barred after a reasonable time. And I say that there should be some reform of the statutes of limitations, and I've set out in the paper throughout what the criteria ought to be for those reforms. Thank you.
Yep.
Thank you very much. I'd like to very, very briefly introduce our next three speakers, starting with Master Sandler, who is seated to my left. Following him will be Alan Mark. Then we'll return to Master Sandler again. And then finally we'll conclude with Peter Atkinson, who is now taking a seat to my far left. After that, we'll have a short coffee break. I'd like to make it no more than 10 minutes so that we can get back in here and continue with motion matters. Thank you.
Thank you, Yvonne. If you could find Chapter E in the material, and particularly starting at page E24, it'll help you following along what I have to say. This is a very short mini paper. A little background before I begin. This is really at page E24. Before 1985 and the Courts of Justice Act, the only provision on the subject of court files at all was the Judicature Act, which provided in section 129 that the public had access to and was entitled to inspect books of the Supreme Court containing records and entries of writs and judgments. That's what it said. And there was nothing about confidentiality or sealing up court files. And there were two early cases, one of which is noted here at the bottom of page E24, B versus P, where the master held in a divorce situation that there was an inherent jurisdiction to seal up court files to prevent personal or social or financial embarrassment in a paternity suit. Now, of course, in a paternity suit, the allegation was that somebody is the father of a child, and the master there held that if, in fact, the person alleging paternity turned out to be wrong, that would be highly embarrassing to the alleged father, and therefore sealed up the court file. He analogized to a section in the Family Law Reform Act that then existed at that time about sealing up court files to protect confidentiality of financial information, and said he thought he had inherent jurisdiction to seal up a file in a paternity suit. Another case which isn't noted, you might just make a note of it for more historical reasons, is called Anderson versus Anderson. The site is 26 OR 2nd 769. And in that case, Madam Justice Boland was dealing with financial documents in a divorce action before 1979, that is, before there was even any provision in the Family Law Reform Act. So she was dealing with a situation where there was no statutory discussion at all, and held that sealing up was appropriate where it could be shown that the disclosure of financial information to the public might harm one of the parties. So that was an early pre-legislative exercise by the court of its jurisdiction. That was Anderson. Then the Family Law Reform Act came along, Section 23, dealing with protection for financial information. Then in 1985, the Courts of Justice Act established a general section, and the Family Law Reform Act, Section 23, which dealt with confidentiality of financial information, was repealed by the Family Law Act. So there is now no longer any statutory provision in the Family Law Act. The Family Law Reform Act section is gone, and what we're left with is Section 147 of the Courts of Justice Act. There's a typo on page E24 where it says 147.3. It should say 147.2. That's the statutory provision. And it says that a court may order that any document filed in a civil proceeding be treated as confidential, sealed, and not form part of the public record. Now that's because sections 147 sub 1 and 3 give the general accessibility right. That section says any document filed in a civil proceeding in a court is available to be seen. Any document filed in a civil proceeding in a court is available to be seen, as are lists of actions commenced and judgments entered. So there is this power in the court to seal up or order that any document filed in a civil proceeding be treated as confidential. Now, presumably, if you can get it for one document, you can get it for all documents. So theoretically, there is a right, I presume, not only to deal with specific documents, but to deal with the general court file. But you might be more successful in seeking some kind of order for specific documents than the entire court file, depending on what it is that you want to protect. But you can structure your motion either in respect of a specific document or in respect of all the documents if you're gutsy. Now, of course, there is nothing in the legislation about what the test is. Interestingly enough, on page E25 of my lecture, somebody made a charter argument out in Alberta on a similar section, and the court held that the charter argument failed and that the statutory power for a court to seal up files was a valid exercise of legislation and not contrary to the charter. That's in Alberta. Now, Howes is an interesting case because it went all the way to the Supreme Court of Canada. But the interesting thing about Howes was that they were not dealing with documents that were filed. What Howes was about is someone who tried to find missing persons, and he wanted to get into the financial books and records that the accountant kept of monies paid into court by mortgagees and other people who owed money, but they didn't know who it was owed to, so that this person could try and find out something about missing heirs and missing persons and try and then get business and track them down. So he was trying to get access to the records of the accountant, and the court said no and made the point that that right of access wasn't granted by the statute, and therefore the accountant was correct in retaining that information and not allowing Howes access to it. And there was an appeal taken to the Court of Appeal, dismissed, leave to the Supreme Court of Canada, refused. So it's interesting, but not helpful on a daily basis. In the middle of page E25, there's a reference to Pacific Press and Vickers and Palmer in British Columbia. The only important point there is that newspapers have the right to challenge the orders that are made. So even if both sides consent, that isn't the end of the matter, because the public and the newspapers, as if you like, an element of the public, has the right to come to court and challenge these orders. Now, McCormick and Newman is an Ontario case under the new rules, and in that case, Peter Newman asked the court to seal up the court file because there was an action whereby a plaintiff alleged that Peter Newman had breached his obligation of confidentiality. The action was settled, and Newman was worried about that the mere allegations of the plaintiff could harm his career. And the court held that this case was different from patent cases, trade cases, financial statements, and family cases, and that he was not entitled to the order. Sabara and Sabara is what I would call a garden variety case. Wealthy family, divorce case, a husband under an obligation to disclose financial information in the context of the divorce action, seeking confidentiality with respect to the documents filed. Master Cork said no, but if you read the case, you'll see that it was really based on the insufficiency of the evidence in that case. The affidavit was sworn by the solicitor. It was very general. It was not specific. So what the case really is about is how persuasive, detailed, and direct, and if you like, specific you have to be in showing the harm that's going to come to the client if these documents are revealed. Master Cork has made confidentiality orders in certain divorce cases involving extremely wealthy families where it was able to be shown that the disclosure of the information might well cause a financial harm. English Mold and Leader is a very interesting case. It was a motion there by a defendant who was also being investigated by the police in relation to a criminal charge for an order that the plaintiff not use or divulge information given by this defendant on discovery to anyone, and for an order sealing up the transcripts of the examinations for discovery, and that they not be used or divulged by anyone, parties or court officials, to anyone, including the police. I held that the principle in lac minerals, that's the case which says that there's an implied undertaking not to use documents obtained through the discovery process outside of the action without leave, that principle in the lac minerals case would give the defendant the protection it needed. I saw no power under Section 147.3 of the Courts of Justice Act to make any prevention order preventing the plaintiff from using or divulging information. The section speaks about treating any document as confidential, not preventing people from using or divulging the information. And I noted that Section 147.2 deals with documents filed in the court, and Rule 34.18.3 provides that transcripts of discovery shall not be filed. Thus, the transcripts were not part of the public record, and no order needed to be or could be made. All you had to do was make sure that the discovery transcripts weren't filed. But then there was a broader policy, and that is whether people being investigated by the police should be entitled to prevent such an investigation. And I thought not. I thought that these people had enough protection under the Canada Evidence Act, and I referred to Stickney and Trews and Casse Populaire and Huerten, which dealt with the issue as to whether or not you had to endure discovery at the same time that you were either being investigated or being charged with a criminal offense in relation to the same fact situation which gave rise to the civil action, and both those cases held that you did have to endure discovery and that the Canada Evidence offered protection. The most important case, and it's very recent, is S versus C in, I think, the second or third last pamphlet copy of CPC, decided last November but just recently reported. That action was brought by some victims of a sexual assault against the person who did it, but the person's bishop and the Episcopal Corporation for whom the bishop worked, presumably on the theory that the bishop ought to have known that this man who did the sexual assault was a potential sexual assaulter and should have done something about it. That's the nature of the action. And the plaintiff obtained an ex parte order under Section 147.2 that the entire court file be sealed up and treated as confidential. The defendant took no interest in the original motion at all. So here's a situation where the parties are happy. Both parties are happy with the confidentiality order. The person who sought to set aside the order was a newspaper, and the court found that the newspaper was affected by the order and had standing to move to set it aside, arriving at the same result as that British Columbia case. Court also held that 147.2 should be resorted to sparingly in the clearest of cases and on the clearest of materials, where the interests of justice would be subverted and or totally innocent persons would unduly suffer without any significant compensating public interest being served. And only in those circumstances could the order be justified. And the material before the court in that case was insufficient to support the original ex parte order, and it was set aside. So in summary, even if the parties are in agreement, you're still at risk from newspapers, media, or others, members of the public. Number two, if you're going to try and get an order, think about whether you can limit it to specific documents, because the narrower your motion is framed, the greater the chance of success, and consider the material, and you have to be specific and really show that your client is going to be significantly harmed if your information is disclosed. I might say that in the area of patents, trademarks, in industrial property, inventions, that sort of thing, these similar types of orders have been made, and I'll just give you a couple of cases. You can write them down and look at them. This is quite common in the area of patents and inventions. Burndy versus Brown, 1978, 5 CPC 266. Warner Lambert versus Glaxo, 1975, RPC 354, English Court of Appeal. Printers versus Holloway, 1961, RPC 77 in the English Court of Appeal. Grant versus Monsanto, 101 DLR 3rd, 594, Alberta Supreme Court. And lastly, Terrapin versus Turton, 1968, 55, CPR, it's Canadian Patent Reporter, page 1, British Columbia Court of Appeal. And all those cases deal with confidentiality, and it's mainly on discovery, and its terms with respect to production and discovery to preserve confidentiality only as between the parties and not reveal it to the public. And they weren't using the section of the Courts of Justice Act or its equivalent, but rather imposing terms with respect to discovery and ordering confidentiality as a way of not disclosing this information to competitors in the context of industrial property cases. Thank you very much.
The topic I'm dealing with is security for costs from shell corporations, and you can find the paper at Chapter F of your materials. One of the significant innovations of Rule 56 dealing with costs was the bringing into force of Rule 56.01d, which now permits you to obtain an order for security for costs from a corporation, even if it's an Ontario corporation, if there is good reason to believe that the corporation does not have sufficient assets to answer for costs. This is a departure because previously it was only in cases of frivolous actions or foreign plaintiffs where this sort of relief could be obtained. But the legislature has recognized, presumably, that there was some evil going on of shareholders using corporate vehicles to obtain various economic benefits, but insulating themselves from obligations, including the costs and legal proceedings. And I guess while the corporate veil has withstood many other assaults when it comes to matters of lawyers' costs, it's not proved quite so durable. But we've all, in one form or another, faced the problem of advising an unsophisticated client that he better settle the action, because even if he wins against the plaintiff, he's not going to recover his costs, and he'll end up paying you more if you go to trial. So invariably, you pay a few $1,000s to the plaintiff to go away, even though your client tells you, but I think I'm fighting with Mr. X, and you have to tell him that you're not really fighting with Mr. X, you're fighting with his corporation. But the rule makes it actually relatively easy now to get security for costs. What you have to show in the first instance is not clearly or prove to some standard of balance of probabilities that the plaintiff does not have sufficient assets in Ontario. All you have to show is that there is good reason to believe that the plaintiff does not have sufficient assets. That recognizes, I think, the fact that the information about the plaintiff's financial condition invariably lies exclusively within the knowledge of the plaintiff. So the test is somewhat relaxed. And I think in many cases, you would be able to meet that test relatively easily. Take, for example, a real estate transaction where you believe that the company, which is the plaintiff, was likely incorporated only for the purpose of that transaction. Transaction was not completed. I think that type of fact situation may well be enough to permit you to, at least in the first instance, satisfy the test. But it's not free from difficulty, and while there are not a lot of cases on it, the cases so far are a little bit difficult to reconcile. In one case, for example, the evidence that the defendant put forward was that there were outstanding writs of execution and that the plaintiff hadn't filed any corporate returns in Ontario. It doesn't really tell you a whole lot about the plaintiff's assets, but the master accepted that that was sufficient to establish the good reason. On the other hand, in another case, there was evidence that the plaintiff corporation had sold all of its undertaking, had entered into a non-competition agreement with the purchaser, was inactive, and the president of the purchaser deposed that, as far as he was aware, the plaintiff was a shell corporation. The master, I think, perhaps wrongly, held that that was not sufficient to show good reason to believe that there were insufficient assets. I think this raises one of the more interesting questions which will yet be decided in the future, and that is whether you can use the rule which permits you to examine a witness on a pending motion on your motion to get security for costs. There is a principle that you shouldn't get the opportunity to examine the plaintiff as a judgment debtor before you have your judgment. That has to be balanced against your right for security for costs. So far, the cases seem to favor the proposition that the plaintiff should not have to submit to an examination of its assets, even if it's brought in conjunction with a motion for security for costs. The case is Drapeau and Livingston. It's in my materials, and that is actually a Court of Appeal case, which makes it a little bit more difficult to get around. But the interesting thing about that case is, in fact, the examination was there permitted. And it seems to have been permitted because the plaintiff had some independent evidence. It had an affidavit deposing to certain statements made by the representative of the plaintiff that the defendant now sought to examine. And the Court of Appeal, without going into its reasons in detail, seemed to consider that sufficient to permit the examination to take place in that case. And I think ultimately where the cases are going to go is that if a defendant can show that the examination is not frivolous, that there is some independent evidence to support the proposition that there is insufficient assets to answer for costs, the examination will be permitted. And that will protect against the frivolous examination, the fishing expedition, or the harassment of a plaintiff with assets, but will not preclude the defendant from getting the information it needs to succeed on the motion. Once you establish that there's good reason to believe there are insufficient assets, you are prima facie as a defendant entitled to your security for costs. The plaintiff can only resist that motion at that point on two bases. One is if it establishes that it does have assets. I think that's clear and I won't deal with it. The second ground, and the one which has been the subject of discussion in the cases, is the plaintiff can establish that it is impecunious and that justice demands that it be entitled to proceed with the action, notwithstanding its impecuniosity. The theory of that is quite simple. The order should not have the effect of depriving a bona fide plaintiff of a bona fide cause of action. But the plaintiff must establish strictly on evidence its impecuniosity, and that is something that's different from lack of assets. Somebody can have no assets but may well be able, through one means or another, to put up the funds for the security for costs. Because the plaintiff must prove that, it is not something which can be admitted. A plaintiff will not be permitted to come to court and throw up its hands and say, I am impecunious, and therefore should not have to post the security for costs. The onus is definitely higher than the onus on the defendant in proving insufficiency of assets. Once the impecuniosity, and it's in this area of impecuniosity that we get into what is the object of the rule, and that is making the shareholder the one to be truly responsible for the costs. The courts have held, and this is a judicial gloss, it's not in the rule itself, but it's clearly the object of the rule. The courts have held that impecuniosity is not proven unless it can in effect be proven that the shareholders of the corporation are themselves impecunious. Because the test which was laid down even under the old rules, and it was primarily in one of Master Sandler's decisions, Eddie and Me Productions, was that the defendant had to, or the plaintiff had to prove that it could not raise or borrow the money. And that left the door open to the argument that that means you have to look at the shareholders' assets, and that's where the cases have clearly gone. So if the plaintiff is going to say it should be excused from posting security, what it in effect means is the shareholders are going to be subject to an examination of their financial affairs, and if they're not impecunious, then the defendant is going to get an order for security for costs. One of the interesting questions is whether it is just the shareholders who should be examined or whose affairs should be looked at, or whether you can extend it to others. The theory of the shareholders being subject to the rule is that they're the ones presumably who benefit from the success in the litigation. But in some cases it may be others. It may be, for example, creditors. There are many situations where the plaintiff's litigation is being funded by creditors, secured or otherwise, to bring in receivables. And if you can show that it's not the shareholder who will reap the benefits, but really the litigation is being sponsored by and funded by a creditor or some other interested person, you may want to argue that it is that person who should be the one to put up the security for costs. Similarly, you may be faced with a situation where the shareholder does appear to be impecunious, but he's living in a big mansion in Rosedale and he's driving a Cadillac, all of which are in his wife's name. Now, it's been referred to tangentially in some cases, but you may want to argue that there you should be able to look at the total family assets of the shareholder and argue that justice demands that if he's living that type of lifestyle, then impecuniosity can't be presumed. Lastly, once the plaintiff does manage in those rare cases to show impecuniosity, that's not the end of the discussion. The plaintiff, in order to be relieved from the obligation to post security, must still establish that justice demands that it be entitled to proceed. While that's a very broad phrase and suggests that there are many factors to be considered, in fact, the cases say that there's only one factor to be considered, and that is, does the plaintiff have a meritorious case? Now, that's a thorny phrase which has given all sorts of problems in the past, and thankfully, Mr. Justice Reed in Wink and Seco, I think, has done us all a favor by going right to the heart of the matter and saying all that can intelligently mean is the case frivolous or not? And I think we've gone through too much law in motions for judgment and interlocutory injunctions, etc., to still be foolish enough to think you can do anything more on an interlocutory basis than ask that question. And Mr. Justice Reed's decision clearly suggests that once the plaintiff can prove it is impecunious and that its case is not frivolous, then in that situation it will be relieved from the obligation to post security for costs. And in this sense, then, the corporation is treated the same as a natural plaintiff in that it will not be deprived of its right to proceed with its action where justice demands. As a closing note, just one word of caution. All these new developments in the field have led to many rather protracted proceedings. When you commence your motion for security for costs, be sure that you include in your draft bill of costs the cost of the motion itself and update it as you go. because there's nothing more embarrassing than after several months of interlocutory proceedings and appeals and all these lovely issues, you report to your client that you're successful in getting an order, that the plaintiff posts $10,000 for security, and you enclose your account for $12,000. And it makes your client wonder whether it was all worth it. So make sure you include that claim in your materials. Thank you.
I'm going to go rather quickly again. I'm in my lecture, chapter E, page 1, E1. And I'm just going to do some of the highlights since we're running behind schedule, and I'm going to take about 5 minutes. But this is a very important subject, the question of what happens when you lose an interlocutory motion and you don't like the result. Can you try again? In other words, does res judicata or issue estoppel apply to decisions on interlocutory motions? In my view, the answer is yes, and I've cited 3 cases on page 1, a New Brunswick Queen's Bench judgment, a Supreme Court of Canada judgment, and lastly, a judgment of the Court of Appeal in Saskatchewan. Now, the quotation there is worth reading. I'm just going to take a moment to read it. If the application to the local master failed because of some insufficiency or imperfection in the material, a second application for the same relief with the faults corrected cannot be made unless with leave of the court granted before the order has been taken out. That's by the court who you lose before. The theory being behind the principle is that the applicant has already got a judicial decision against him on the material he submitted, and the matter is res judicata. And this principle not only discourages careless and indifferent use of material, but prevents piecemeal applications, which is most desirable in the interests of efficient administration of justice. However, a practice has evolved whereby the judge dismissing the application may, and usually does, grant leave to make a fresh application. This is generally granted on penalty of the payment of costs of the abortive application, and so far as I know, the right to grant such leave has never been questioned, and in my opinion, there is an inherent right to do so. The principle of res judicata does not apply to situations where no order was made on the first application or where the judge hearing the application has no jurisdiction. If, on the other hand, the application to the local master was dismissed on the merits, which is most likely the case, an appeal from that decision should have been taken and not a new substantive application as was done here, as it does not appear that any leave was obtained from the local master to launch the second application. So the principle is of res judicata, at least as considered by the Alberta Saskatchewan Court of Appeal, is that it bars all subsequent applications, even on different material, for the same relief, unless leave is obtained, without prejudice to a further application, is the usual language used. Now, I just might point out that the concept of res judicata is such that it not only affects what was decided, but the principle also applies to issues or points which the parties exercising reasonable diligence ought to have brought forward for decision on the particular motion. And that statement is supported by the cases on page E5. There are 3 cases there, Liebig, Dominion Trust, and Fidelitas, all of which lay down the principle that it's not only what was decided, but what could have been decided by the parties bringing forward points that were appropriate to be brought forward and could have been brought forward with reasonable diligence. Now, there are 3 cases going the other way, like in procedural matters. There are always cases going the other way. And this is one, I'll just go digress for one moment. When you're talking in the area of procedure, it isn't quite as bound in stone as perhaps some of the practitioners give the impression in these papers. A lot of procedural issues are seen very differently by different courts. And this is not an invitation to anarchy. I don't think it should be this way. I think that stare decisis should be more strictly followed and applied because it leads to great uncertainty, particularly for the bar and for the lower courts, because you have higher courts going all over the place on the same issue, day by day, week by week, and it's very difficult to advise clients. It's very difficult to carry out your jurisdiction. So I'm not an advocate of this, but this is the reality. So all I'm giving you is a warning. If you have a problem and you see there's a procedural case on it, and it's important enough, and you've got the money, and it's worth it to your client and to the case, and it justifies it, don't be inhibited by one procedural case that you are aware of that says you can't do it. I can tell you that there are very different and strongly held views among the high court judges on practice and procedure, and I say that you take any issue, any controversial issue, and put it before all 44 judges. If you had to do this, and you could argue that however many there are now, and you'd get at least 3 different answers, at least 3, if not more. So keep that in mind when you're considering to what strength you are going to give authorities credence. There are cases, Royal Bank and Barringer, Talbot and Pan Ocean, and Kingston and Salvation Army, which take a more moderate view on res judicata on interlocutory motions. I'd like to turn now to page 5. IAC and go in the middle of page 5. This was a motion by a defendant to set aside a default judgment solely on the grounds that it was a nullity. The judgment was a nullity because the specially endorsed writ asserted a claim that couldn't be specially endorsed. The motion was dismissed. Then the defendant brought a second motion to set aside the judgment based on the grounds that he had a good defense and that he had a reasonable excuse for not defending. And the motion was dismissed on the basis of nemo debet bis vexari, which I translate as one bite at the cherry. Not a very good Latin translation, but in effect that's what it means. You shouldn't be vexed by multiple proceedings. No one should. Now, IAC and Goliski was approved by the Nova Scotia Court of Appeal in a case which I'll get to in a moment. But that sort of makes the point of how important it is to bring all these things forward. Now, on page E6, that quotation that I read from in the Saskatchewan Court of Appeal arose in this fact situation. The defendant applied to a master to dismiss an action because the plaintiff had failed to provide security for costs as earlier ordered. And the defendant lost. I don't know why. It doesn't say why he lost, but he lost. He then moved for the same relief to dismiss the plaintiff's action for failing to post security before a judge. He didn't appeal his original dismissal of his motion by the master. The court held that res judicata prevented that second application. So he wasn't allowed to do that. He ought to have appealed. Now, presumably he lost because his material was defective, not because, I would assume so, it's not clear from the report, but in the quotation that I read to you earlier, it talked about insufficiency of material. So that makes it clear how important, if you do lose, to at least ask for, you may not get it, but at least ask for a term in the order dismissing your motion that it be without prejudice to a further one. Now, following on page E6, in the Talbot case in Alberta, it was a motion by the plaintiff for leave to serve a claim ex juris. The material was inadequate, and plaintiff's counsel asked for an adjournment to file further material, which was refused, and the motion was dismissed. And no provision had been made that the motion could be resumed. The plaintiff then moved again before a different judge on new and better material, and he made the order, and the defendant, after they had been served ex juris, moved to set aside the order permitting service ex juris, arguing that the second ex parte order was prohibited by res judicata. The Alberta Court of Appeal said no, it wasn't, and Talbot and Pan Ocean, and they disagreed with the Saskatchewan Court of Appeal in Lair. Now, the next case at the top of page E7 is interesting. This is the Nova Scotia Court of Appeal. Here, the defendant moved to set aside a default judgment, which was dismissed because the defendant could not satisfactorily account for the delay in moving. You know, to set aside a default judgment, you've got to show merits, a reasonable excuse for not defending, and account for the delay in moving because frequently there isn't a delay, but where there is 6, 9 months, a year, you have to account how come it took you so long once you found out the judgment was given against you. And the defendant didn't deal with that in his material, and it was on that basis the motion was dismissed. The defendant brought a second motion and tried to account for the delay. Court held that the defendant could not bring the second motion because res judicata applied to it, and it applied and approved of IOC and Galiski. So that's a pretty important case. Now, the next case is interesting, and that's on page E7. And this will highlight sort of the problem. The problem is always to decide what the issue was the first time around and what the issue is today, the second time around, and whether it's the same, because it only applies to prevent issues that are the same and that were before the court the first time or that could have been before the court with reasonable diligence. But that isn't what this case is about. The case here is what was decided. Plaintiff obtained an ex parte order renewing a writ of summons, and the writ was served. Now, in today's context, it would be obtaining an order extending the time for service of the statement of claim. For 6 months to serve a statement of claim, it goes by, you get an ex parte order extending the time for service, then you serve the statement of claim on the defendant. That's the situation that this would arise in today. Defendant applied to set aside the ex parte order renewing the writ and was successful. Set it aside. Plaintiff appealed, appeal dismissed. Plaintiff then brought a second ex parte order to renew the writ and obtained the renewal order again. The defendant was again served, and the defendant again moved to set aside the second ex parte order, and the master again set it aside, and the plaintiff appealed again. It was held that the plaintiff was not entitled to proceed as he had, since the issue on the second round was exactly the same as the issue on the first round, and had already been decided. Appeal dismissed. The court drew a distinction between relying on the same activity more than once. In other words, the issue to renew a writ is reasonable diligence in attempting to effect service without being successful. So they first set out what they did, and it was dismissed, and the appeal, that was all dismissed. But then they tried again on what they had done, the same activity to effect service of the claim. So the court drew a distinction between that and relying on entirely new factual basis to try and get the relief, where the first factual basis relied upon was unsuccessful. In other words, so if after the first appeal was dismissed, the plaintiff had then said, okay, we're going to now go out and we're going to, well, they couldn't in that case because the time limit had already passed. The idea that what the court was talking about is, well, if they had gone out and did some new activity, and then based on that new activity tried to get relief, res judicata wouldn't prevent that. But in this case, it wasn't open to the plaintiff to do the new activity because the only thing he could do was to try and effect service, but the time limit had gone by. But it does draw the distinction between the same activity ruled upon preventing a second application, and if there is new activity that you can do, and the court didn't rule on the validity of your new activity, but only the validity of your old activity, then res judicata will not apply. That was the case of Last versus Sewer. And lastly, I would just like to draw your attention on page, bottom of page 9, to this case that I've cited over at page 10, Immobilien and CFI Investments. And this is a very common situation. You move to add a party, plaintiff moves to add a party, and leave is given to add a party and to deliver a statement of claim. And the statement of claim is annexed to the order. And the master says, okay, you can add the party and serve the statement of claim in accordance with Schedule A to the order or in accordance with the notice of motion or whatever. And then it's done. And then the defendant comes to attack the pleading itself. And the argument is you should have attacked that on the motion that you fought to be added as a party. And the defendant says, yeah, but we didn't talk about, I was objecting to being added. We didn't talk about the pleading. And what Master Pepiot held was it doesn't matter. It was open to you to contest the pleading issue at that time, and you didn't, and therefore you can't come and attack it now. And res judicata applied. Lastly, I would just point out that consent orders will bar subsequent proceedings. 3 cases cited there. These were all orders dismissing actions on consent, and then plaintiff had a change of heart, tried a second time, and res judicata was held to apply. And lastly, the question, if you consent to an order, usually an order dismissing an action or consenting to the delivery of an affidavit of documents or whatever, what are the effective consent orders? If you change your mind, can you get out of them? And the basic answer is no. Chattel and Rothbart, Davis and Kalkust, where a motion to set aside a consent order dismissing an action was dismissed, as was Kirsch and ICBC. The courts have held that a consent order is a contract between the plaintiff and the defendant or their respective lawyers, and it cannot be set aside unless there is fraud, misrepresentation, or any of the grounds that would vitiate a contract. So watch out before you sign your name to a consent to an order. Thank you very much.
I'll attempt to be very brief because I'm sure that everyone is ready for a coffee. The topic that I'm to cover this morning is the significance of the undertaking as to damages, which is given on an application for an interlocutory injunction. Usually the undertaking is found in the affidavit filed by the applicant, or it can be placed in a separate document, but it is always given on an application for the interlocutory injunction. At the time that one is scurrying around obtaining these affidavits and getting ready for the injunction application itself, we don't always tend to put as much emphasis on making our client understand what that undertaking really means. The decision of the Court of Appeal in Nelson, Burns, and Gratham, which is referred to in my short paper, underlines just how important that undertaking is. In the Nelson Burns case, 2 employees had gone off and set up a competing business, and they were doing quite well with that business when Nelson Burns brought an application for an injunction. Nelson Burns was successful and put the new company out of business. Usually that resolves the case because there aren't too many defendants who have been shut down who can afford to go on to trial. But in the Nelson Burns case, even though their business had been shut down, the action proceeded to trial, at which time the defendants were substantially successful. In fact, during the course of the trial, Mr. Justice Hughes dissolved the injunction. The defendants then brought an application before Mr. Justice Hughes to have an assessment of damages arising from the undertaking, but Mr. Justice Hughes said no dice. He didn't like the conduct of the defendants, and he pointed out that they had, in fact, breached a patent which they had to pay damages for anyway. So in effect, the defendants were going to have to pay damages for a patent infringement, and they were also denied damages on the undertaking. That case was appealed to the Court of Appeal, and it's the Court of Appeal decision that is referred to in this paper. The Court of Appeal accepted the argument that obtaining undertakings is a lot easier now because of the American cyanamide decision. And the Court of Appeal, I take from their decision, isn't all that enthusiastic about the fact that so many injunction applications are being granted. So in order to make litigants appreciate just how important the undertaking as to damages is, the court went on at some length about the importance of that undertaking and the fact that applicants will not be allowed to wiggle out of them. That decision was, leave to appeal was sought from the Supreme Court of Canada last month, And although the application was fully argued, the Supreme Court of Canada turned down the leave application. The undertaking, therefore, is very significant, and in the past, I don't think I've ever seen in the application or in the interim proceedings any cross-examination about the undertaking, whether or not the applicant has the funds to finance that undertaking in the event the applicant is successful, or questions like that. So I expect that as this decision becomes better known, it may well turn out that in the application phase itself, that applicants will be cross-examined as to the undertaking and as to their ability to fulfill it. There isn't a lot of authority in this area. The Court of Appeal looked at the Viewager decision of the Supreme Court of Canada, and that decision simply stands for the proposition that in the normal case, if you lose a trial, you'll have to honor your undertaking, but it does say that in special circumstances, trial judges have a discretion. The special circumstances are really narrowed now because of the decision of the Court of Appeal in the Gratham case. It will be the rare case indeed where the undertaking as to damages will not have to be honored. Thank you.
Master Sandler and Theodore Kirshner. Following the presentations, we'll open up for questions from the audience, and I'm sure there will be lots of questions. Thank you.
Could you turn to the lecture at page 29, which is where I'm going to begin? I find it's much easier for all of us if you have the paper there and I can make some quicker references. We're always under time pressure here. Subject here is what master's jurisdiction, what's new since 1985. Just make the point briefly on the middle of page E29 that the Courts of Justice Act provides that a master has all the jurisdiction as is conferred by the rules of civil procedure. Other statutes can confer jurisdiction directly. Three that come to mind are the Construction Lien Act, dealing with construction lien matters, including references, which are really trials. Section 38 of the Mortgages Act, which is a simple little thing dealing with sale without notice. And there's a section, obscure section in the Personal Property Security Act, which confers jurisdiction statutorily directly on a master. Now, turning to the rule which confers jurisdiction on masters, 37023, I just want to highlight some important parts of this rule. The legal activity that you're thinking of doing must be a motion, because it's only a motion that a master can hear, not an application, except where it's conferred by statute. The Section 38 Mortgages Act and the Section 45 Personal Property Security Act are in fact applications, but they're authorized by statute. But if you're getting your jurisdiction under the rules, it must be a motion, and it must be in a proceeding in the Supreme Court. So you always have to ask yourself, is what I'm doing a motion? Is it in a proceeding in the Supreme Court? Then there are some specific exceptions that I just want to review, and one of them is that the master can't do something where the power is expressly conferred on a judge by statute or rule. I get this all the time. Motions to transfer cases from district court to Supreme Court or from Supreme Court to district court. The section dealing with transfers in the Judicature Act says that it's to be done by a judge. Since it's expressly conferred on a judge to do it, a master can't do it. And there are numerous other examples of that. And constantly I'm being asked, usually on over-the-counter stuff, to sign these orders. I suspect it's some legal secretary or law clerk or somebody, or maybe one of you who hasn't read the section. Just do it. You say to your secretary, prepare the papers and do it. But you got to look at the section. Does it confer the power expressly on a judge? If so, master can't do it, even on consent. Now, where a motion is one to set aside, vary, or amend an order of a high court judge or local judge, the master can't do it. And this is again on consent or otherwise. And I get motions to vary provisions dealing with setting an action down for trial, or I can't remember them. But you have to ask yourself, is this varying, amending, or setting aside an order of a high court judge or local judge, even on consent? If so, master can't do it. But if it's time limits in such orders, to change time limits in an order, the master can do that unless the time limit was in an order that a master could not have made in the first place. So for instance, let's say I say you have to do something within 20 days. And then there's an appeal, and the appeal is dismissed, but the 20-day time period, of course, was long gone because the appeal was argued 2 months later. So the judge on appeal says within 20 days from the date of the appeal. And then somebody wants to get an order extending that time limit because they can't make it. Well, I could have made the original time limit order, let's say it was to amend a pleading or something, and impose that time as a term of that order. Therefore, the fact that there is an appeal and all you're doing is extending a time limit, but it's a time limit in an order or a motion that I could have heard originally, I can extend the time. But to give you two examples, if it's an injunction or a receivership and there's some time limits in those type of orders, I couldn't have heard those and therefore can't extend the times in those orders, even though it's merely extending time. If the master couldn't have made the main order, then he can't extend the time. The well-known one, the master can't issue judgments even on consent relating to infants or other persons under a disability. And you cannot hear any motion in an appeal. Now, I raise this as a problem. Can a master hear a motion to remove solicitors of record from the record where the trial is over and the case is now on appeal? I had one of these just yesterday. Now, I take a very practical approach to this. What do we want to bother the Court of Appeal judges in relation to a motion to remove solicitors? In fact, this was contested, and it wasn't contested by the client of the lawyer, but it was rather contested by the other side of the case, the other person who was representing himself. And I think he applied the theory that whatever the lawyer did, if it was good for the lawyer, it was bad for him. So he didn't know why he was opposing. I mean, he told me all these reasons, but he couldn't believe that there's something happening that wouldn't have adversely affected him, so he was in there fighting like cats and dogs. But it was in the Court of Appeal. Well, I took the position that it's not a motion in the appeal because it really doesn't have anything to do with the appeal. If it sought leave to extend the time for filing a notice of appeal or something about factums or appeal books or whatever, anything procedurally in relation to the appeal, then I couldn't do it. But I felt, stretching it a bit, that if it's a motion to remove the solicitors or solicitors of record, that isn't confined to the appeal. That has to do with both trial and the appeal. It isn't in the appeal per se, but it's in the proceeding as a whole, and I did it. So if you've got that situation, I'm prepared to make those orders on practical grounds. I don't think that I'm dealing with the appeal itself. Now, the next part of the lecture deals with specific cases where dealing with master's jurisdiction. I'll just run through these relatively quickly. Section 38 Mortgages Act, someone raised the question as to whether or not the master could hear this. Master Pepe had held that it wasn't a motion, it was an application. And the argument was the master can only hear motions under Rule 37. But Master Pepe had pointed out that that's true. But there can be the conferral of jurisdiction on a master directly by statute, and that's what Section 38 did. So that even though it was an application that a master could hear because the statute conferred the jurisdiction directly. The rules didn't, and therefore okay. Section 64 of the Succession Law Reform Act, providing for interim support in a Succession Law Reform Act proceeding, the master has jurisdiction, so said a judge, analogizing to the power for interim support in divorce and in other matrimonial and family law matters. So the Section 64 interim support provision, which doesn't make it clear who can make such an order, just says the court can, but doesn't say who master has jurisdiction. Number 3 is important. Interim restraining and preservation orders under the Family Law Act, a master does have jurisdiction, even though one could argue that a restraining order and preservation orders, particularly restraining orders against dissipation of property, are injunctions. But the court held no, they weren't injunctions. They sound like injunctions, just like motions to restrain the lawyer on the other side of the case from acting. Sounds like an injunction, but somehow miraculously it isn't. And a master does have jurisdiction to make those orders, Angelopoulos. Schuster is simply the case under the Family Law Reform Act that came to the same result under that statute. Payment out of court of funds paid in under Section 18 of the Insurance Act. Now, this is interesting. Here, Section 18, there are these sections. There's one in the Insurance Act, there's one in the Mortgages Act, there are a couple of others where it talks about the power of people who have money to pay that money into court. And it's sort of like interpleader. They got this money, they don't know who to pay it to, they want to just pay it in and get away, walk away. That's what the Section 18 of the Insurance Act was about. So the insurance company applied to pay this money in. And the master held there was no jurisdiction because it's an application authorized by a statute. And the Section 4, Rule 14 says that proceedings that are authorized to be made by statutes, unless the statute specifically says that a master can deal with it, such as the Mortgages Act, are to be dealt with by originating, the originating proceeding is an application. So I think it was Master Pepiot held that there was no jurisdiction to make this order. Now you should contrast that with the next case, which is Schritter-Reiser versus Morris. And that has just been, it was reported at the master's level, 60 OR 2nd 704, and on appeal, 62 OR 2nd 177, just recently reported. And the interesting thing here was nobody thought about the jurisdiction, but this was a proceeding, a legal activity. I like to use the neutral word, a legal activity to discharge a mortgage where the mortgagor had the funds and there was disagreement as to who the mortgagee was or where the mortgagee was, and the mortgagor just wanted that mortgage off title so that he could sell and let the mortgagee and people claiming fight over the money, much like interpleader. And Master Clark said that he couldn't do it not on jurisdictional grounds, but rather on the interpretation of the statute, and he considered the merits of the motion and said no. And the applicant appealed, and the appeal was allowed, and Mr. Justice Rosenberg said yes. But nobody raised the question of jurisdiction. But it seems to me quite clear that Section 11 of the Mortgages Act, allowing this legal activity to go forward, is a statutorily authorized legal activity, and by reason of Rule 14, should be done by way of application. And that Master Clark was right, but for the wrong reason, that he didn't have any jurisdiction. So I happen to think that Schritter-Reiser is wrong, and that CIBC and Zurich Insurance is the correct approach for all these statutorily authorized applications. Of course, the issue wasn't raised, and what can you make of Schritter-Reiser and stare decisis from the point of view of jurisdiction? I don't know. Motions to extend the time for a plaintiff to set down or list for trial where the time limit is specified in an order of a judge at a status hearing. This is very common. The judge at a status hearing says to the plaintiff, you better get this case set down for trial by 6 months from now, or else we're going to dismiss it. And the plaintiff doesn't. The master has no jurisdiction to change this because, of course, that would be varying an order that a master had no jurisdiction to deal with in the first place, because status orders under the status rule in 48 are to be dealt with by a judge. So a master can't extend the time. But the 3 cases that I've cited there are cases on who can. do that. And the latest one, McGraw and Dresser Canada, is the latest on this subject, which says that there is jurisdiction to do it and it can be done by a high court judge. So if you're in that situation, read those 3 cases and they'll tell you to whom you go to get an extension of time. Number 7, motion by a defendant to dismiss an action of an infant plaintiff for delay. The master does have jurisdiction, Petrakis and Mount Sinai. Number 8 is important, and this is relatively new. The motion to remove the opposite party's solicitors from the record because of a conflict of interest. The master now has jurisdiction. This is a divisional court case, and we've been getting a lot of these lately. And they're difficult to deal with because they deal with conflicts between one of the parties and the solicitors, and they acted for some other party. They're difficult to deal with, but that's where you go. Now, Cineplex and Odeon and Toronto Star is an example of what I was telling you about, where the High Court judge imposed a time limit, but it was in relation to a pleading delivery situation, and the master held that he could extend the time because it was an order that he could have made in the first place. Number 10 is important. A situation where a client doesn't show up on an assessment through default, and he now wants to do something about it. What he does is move to set aside, it's like a default judgment, only it's a default report. There was some issue as to whether or not the master could deal with that, and Ruby and Jaffe now holds that a master can, so motions to set aside default reports under the Solicitors Act, same as setting aside default judgment, can be done by master. Now, number 11 is interesting. This is a motion by someone who has to pay a lawyer's bill, but who isn't the client. Usually it's a mortgagor or some kind of private indemnity situation where not the client, but somebody other than the client is obliged by law to pay a lawyer's bill, and that person wants to get the bill assessed. He must bring an application under Section 8 of the Solicitors Act to refer it to taxation. That person cannot take out a praecipe order as the client can. He has to get an order. The question is, who can make such an order? And I held in Conrad versus Quinnell, which is just reported in the last OR, or 2 weeks ago, I think last week, that a master does have jurisdiction to make that order. And I relied very heavily on a case called Peel Terminal and Lee Wooten in the Court of Appeal under the old rules, which I won't get into it because I don't have time, but it's on the basis of that case that I said that a master has jurisdiction, because but for that case, I would have thought that a Section 8 Solicitors Act legal activity is a statutorily authorized activity which under Rule 14 is to be dealt with by application, and therefore, since it's an application and not a motion, a master doesn't have jurisdiction. But if Peel Terminals is right, then I'm right. And if Peel Terminals is wrong, then I'm wrong. And I think Peel Terminals is wrong. But of course, that doesn't matter. I take it that Peel Terminals is right, and if it is, then I'm right, because what the judge said there was not an application, but rather, and this was Mr. Justice Zuber's words, a proceeding in the nature of a preliminary beginning. That's his words. An activity in the nature of a preliminary procedural beginning, not an application, in his terms, not an originating notice of motion, was an interlocutory proceeding. Master would have had jurisdiction, except for the fact that there was a hole in the statute which had to be it required the inherent jurisdiction of the court to fill, and since masters don't have inherent jurisdiction, only a judge could do it. Interestingly enough, that hole has never been filled by the legislature. But the point is that he held that that proceeding was not an originating motion, and of course, in our new terminology, not an application. So, interesting. Motion to discharge certificates of pending litigation, now I think well known that goes to the master, and we hear about one of those a week, if not more. The Bonaventure case, which Tom Heintzman referred to, making it clear that a master has jurisdiction now to hear stays of actions in relation to issues of forum convenience. I'm not sure I agree with him where he said that if lis alibi pendens is the basis the master doesn't have jurisdiction. You must read the Bonaventure case very, very carefully to see whether or not, if you have defendant served in Ontario, not ex juris, but in Ontario, and that defendant wants to stay in action in Ontario because of another action pending elsewhere, can he apply to the master? I think Bonaventure may go so far as to say the master has jurisdiction. It depends on how you read it. It's arguable. Now, then on the next page, number 13, these are some examples where the rules talk about remedies, and the question is, who can deal with these? Number 13 in my paper, a motion to decide the issue of compliance by a party with its obligation under Rule 53031, which has to do with expert reports. And the argument is that what was delivered, in order to call an expert, you have to deliver the expert's report so many days before the trial. Something is delivered. You look at it, you say, this isn't an expert's report, this is a scrap of paper. And so you want to somehow get relief and say, you haven't given me an expert's report, as the rule talks about, you've given me a piece of paper that's nothing, and I want compliance with the rule. I held that a master has no jurisdiction to review and scrutinize that piece of paper to determine whether it's an expert's report or not within Rule 53. Neither does a motions court judge, in my view. Only the trial judge has the power to do that because it relates to the trial. And the cases of McEachran and Transmetro are two reported cases where the judge at the trial does scrutinize the report to determine whether or not it's a sufficient disclosure to then allow the expert to get into the witness box and testify, the report having been given in advance. So I don't think you can seek compliance by going to the master. 14 deals with a motion before trial to allow a party to prove facts by affidavit rather than by witness viva voce under Rule 53021. In this case, the master does have jurisdiction to make an order because the rule says either at or before the trial you may move for that relief. So since you can move for relief before trial to get an order that you can call to prove a fact by way of affidavit as opposed to viva voce witness, but you need leave, a master has jurisdiction, the case is there. Motion, next one, 15, a motion before trial to set aside a notice of intention to call an adverse party as a witness served under Rule 53071. The master has jurisdiction, so said the case of Haviv. I query whether or not that issue should be left up to the trial judge in the same way as supervising expert reports, but there is the case. Number 16, a motion to set aside a request to admit served under Rule 51. Others that you're seeking